Good afternoon and welcome to CondoWise Learning Series, session number 19, Fraud in Condominiums. We don't want you to be the next victim, so we're dedicating our next three sessions on the darker side of condos. And to those of you who celebrate the 4th of May, may the 4th be with you. For those of you who are battling the dark side. As you know, CondoWise is open to the public, and so please let your directors, your property managers, your unit owners know about our series so they can learn more. And our advice is not actual legal advice. It's just general advice. So we strongly recommend that you speak to your corporation solicitor to go further on the topics we're talking about. Next slide, please. I'm happy to have with me today Julia White, Jonathan Wright, Ashley Winberg, and Shannon Penny from our team at Aaliyah Associates to talk about this topic today. Next slide. So Shannon, without ado, why don't you give us an update on what's going on in the condo industry?
Perfect. Thank you very much, Patricia. Okay, some of you may be aware that CCI Toronto, on behalf of all CCI chapters, provided comments to the Ministry of Government and Consumer Services in response to the Ministry's request for written comments as part of the Ministry's consultation on condominium insurance issues. So condominiums have been experiencing substantial increases in insurance premiums and deductibles, and some condominiums have been finding it difficult to secure insurance at reasonable rates. CCI's comments were submitted to the Ministry on January 31st, and I will put a link to the full copy of the submission in the chat for those interested in reading that. On January 1st, a bylaw for vacant home tax came into effect in Toronto. The tax on vacant homes in Toronto will apply to residential units that are capable of being occupied and that are not the principal residence of the owner or occupied for residential purposes by one or more tenants for at least 6 months of that year. For the purposes of the tax, a principal residence is a residential unit occupied by a person, either alone or jointly with others, and where the person is a resident. All property owners will be required to self-declare the status of their residential home each year, and this will determine the home's occupancy status and whether the tax is payable. If an owner does declare their home as vacant, but is not a principal residence, they will be required to pay a tax of 1% of their home's current assessed value. The tax on vacant homes will be payable for the first time in February 2023, and it is based on the occupancy status during the prior year. The goal of the tax is to change the behaviours of property owners who leave their residential properties unoccupied and compels them to sell or rent out those properties to increase housing supply. I will put a link in the chat as well to access a full copy of that bylaw. So moving on to smoke detectors in condos. A recent fire in a high-rise building in Toronto resulted in the death of one resident. And as a result, fire departments in the GTA have stepped up their enforcement and inspections. The Ontario and national fire codes require regular testing of smoke control systems in a building in order to ensure that they are operating properly in accordance with operation and test procedures. Buildings are required to maintain records of these tests to prove compliance. The current penalties for violating the fire code come with a maximum fine of $100,000 for corporations. So it is very important that those are being complied with. Steps need to be taken to ensure smoke control systems are functioning correctly. The first and most critical step is for condos to determine whether they have a smoke control system maintenance and testing procedure in place. If one has not been prepared for your condo, a professional engineer or architect must be retained to create a specific plan tailored to the systems that exist in your building. Every building is designed differently, therefore it is crucial that those procedures are tailored. And a reminder to all, CCI Toronto opened its applications on May 1st for nominations for Condo of the Year. Each condominium that has shown itself to be an outstanding community will be chosen as Condo of the Year, and the award winner will be announced in the fall at the CCI Toronto AGM. And for anyone interested, I will put the link in the for the application in the chat. So thank you, and I will pass you back over to Patricia.
Thanks, Shannon. Next slide, please. So we have a poll for you. Has your condominium been a victim of fraud? If we could put that up on the screen. And sometimes the question will be, do you even know if you've been a victim of fraud? But that's what we're going to explore today. So over the next 3 webinars, as I mentioned, we're going to be looking at the darker side of condominiums. Unfortunately, there is a dark side where people and organizations try to perpetuate a multitude of illegal activities over condos. We don't want your condominium to be the next victim. Today, we'll be discussing fraud in condominiums. In our next session, we'll be talking about human trafficking in condominiums. And in our 3rd session, we're going to take a deeper dive on fraud by looking at cyber fraud in condominiums. So what exactly is fraud and why are we talking about it? Well, according to Merriam-Webster, fraud is the intentional perversion of truth in order to induce another party to, or another to part with something of value or to surrender a legal right. Thanks, Shannon. Thanks, Justine, for those results. So no, it has not. It seems to be the dominant, which is great. So you're doing something right. And we are going to explore this more to see where fraud shows up. But generally, think about fraud in a few baskets. Asset misappropriation by service providers, bribery and corruption by board members and service providers, financial statement deception, misleading people about the adequacy of the assets of the corporation. So we're focusing on this topic because it's something we want to avoid because it can be overlooked. So we're going to move over to John now, and John is going to take us actually through a scenario, and then Ashley's going to take us through a concept, or Julia, I'm sorry, is going to take us through conflict of interest, and then Ashley's going to talk to us a little bit about collusion. Okay, John, if we can move to the next slide. Thanks.
Thanks, Patricia. So I noticed a lot of you haven't experienced fraud in your condo, and you may be asking yourselves, well, how does fraud in a condo actually show itself? So we put together really a worst case scenario, not to say that this happens in every condo or even the majority of condos, but we sort of packaged everything that we could think of that would be possible that could happen and put it into this scenario for you. So I'm just going to read through it, and then we'll sort of identify some of the issues of fraud that we've seen in this scenario. So firstly, we've got a condominium corporation that has a healthy reserve fund. We've had stable increases in common expenses year over year just to keep up with maintenance and repair of an aging building. The reserve fund studies have been completed in accordance with the Act, and we've got a proactive board that addresses everything on time, competently, and with the advice of legal counsel and a good property manager. At the most recent AGM, all the directors' terms are up. They don't run for re-election, and 3 new board members are appointed. The new board member's first order of business is to terminate the long-standing property manager. If we could have the next slide, please, Justine. Property manager comes in, tells the board that the condo needs its balconies replaced. Turning to the reserve fund study, does not call for the balconies to be replaced for another 15 years. Property manager then tells the board that a special assessment is needed and that $20,000 per unit needs to be assessed. That assessment goes through, the board sort of buys into this, we need to do the balcony project. Nobody's quite sure why, but that's what's happening. The work starts immediately. There's no tendering process. There's no review of contracts by legal counsel. Simply put that the property manager's recommended contractor comes in and starts doing the work. A few months into the project, we have a property manager advising that actually more funds are needed because of change orders and that another special assessment is needed. That goes out. And on the next slide, please, Justine. That special assessment is really the second special assessment is really the red flag or the alarm bells for a lot of owners. The contractor's rarely on site, and the owners requisition a meeting to replace the board. inquiries aren't answered, property management's not responsive, the contractor's never around, a lot of questions asked about what's happening to their community. A lot of intelligent unit owners are looking at the reserve fund study, seeing that the reserve fund study doesn't call for the replacement of balconies, that the reserve fund study, the funding is all there, the reserve fund has a healthy amount in the bank account. We have then the board being replaced at a requisition meeting, and the former board members that everyone agrees were competent, looked after the interests of the corporation, etc., all come on until the next AGM, and they're duly elected at this requisition meeting. When the new board comes in and does a bit of a deep dive into the documentation that they have or don't have, turns out that the contractor is actually the property manager's brother-in-law. The new board then discovered that the property manager was actually the brother of another board member. And the minutes of the meetings disclose no conflict of interest being declared that would be required under the Condo Act. The board also finds that there were no quotes obtained for the brother-in-law of the property manager. There was no tender process for the work to be done. There was no consultant that was brought into, or that was not brought in to look at the balconies themselves or to opine on whether they actually needed to be replaced. And the contract with the contractor was actually 1 page long and basically just outlined the fact that I'm going to do this work and this is how much you're going to pay me. On to the next slide, please, Justine. And we find out that the board members all had upgrades to their units at a rate far below market price. And the contractor was actually paid in full for the project, no progress draws or any certification of work. The work, when it was assessed by an engineer, was only 25% done, and the contractor has now disappeared. And as I said at the start, before going through this scenario, this is worst case scenario, of bits and pieces of things that we've seen over the years thrown into a scenario to sort of outline all of the issues of fraud. And I'm sure there are a lot of people here saying, well, that's wrong, that's wrong, that's wrong, and that's wrong. And each of these things, for example, like the balconies weren't to be done in accordance with the reserve fund study for another 15 years, or a special assessment despite a healthy reserve fund study, aren't necessarily fraudulent. They can happen legitimately. But when everything is put together, alarm bells should start going off. For example, contractor not being on site, multiple special assessments being levied, especially when there's a new board, new property manager, the reserve fund study not claiming or not declaring the work needing to be done, no consultant being on the project. All those things are red flags, but again, put together, indicative of a bigger problem. Now, when we look at these things, there's not necessarily, for example, a conflict of interest that everyone can see. Property management being related to somebody and the contractor being related to property management isn't something that maybe everybody would know right off the bat. But there are certain things that the condominium corporation can do to protect itself from those type of scenarios. When we look at, for example, the Condominium Act, it requires under Section 40 and 41 disclosures of conflict of interest. It doesn't necessarily prohibit conflict from happening. It allows them when there's been a disclosure. I believe Julie is going to talk briefly about the gaps that can be filled in the conflict of interest sections of the Act through bylaws, etc. One of the biggest problems that we've seen, this is an aside, from the conflict of interest section of the Condo Act, it only speaks to material transactions and contracts. It doesn't speak to, for example, litigation. So if there's a board member that is subject to some litigation from the condominium corporation, he doesn't have to declare that, or he or she doesn't have to declare that, for example, before being part of discussions about that litigation. It makes sense. Our advice is always that that individual should be excluded from those discussions, but the Act isn't, in my opinion anyway, wholesome enough to address all necessary conflicts of interest. In terms of what the condominium corporation can do if it was faced with a similar scenario or parts of that scenario, for example, and you were to come on to the board and wonder, what on earth do we do next? Call the police would be step one. But following on from that, gather the minutes, gather the documentation, the contracts, any tendering documents, any, for example, email exchanges that are in the files, any emails to property management, things like that, and package that all up. And then when we have all that, generally the first thing that we would look to do then is to bring in some sort of forensic audit or forensic auditor to look at exactly what's transpired, how far things are, off the center, as it were, and how bad things are before we look at commencing any litigation against those type of individuals, whether it's the property manager, the directors, or the contractors. I think that's really my part for now. I'm going to hand it over to, I believe, Julia.
Thanks, John. So now we're going to go into conflict of interest. So what is a conflict of interest? Generally speaking, a conflict of interest is a situation where an individual has the ability to obtain a personal benefit or a gain, whether direct or indirect, from a decision made in their official capacity. Who can be in conflict? So today we're going to talk about directors and officers, property managers, and legal counsel. So first we're going to talk about directors and officers. Do they have a duty to disclose conflicts, and when does this duty arise? So as John briefly mentioned, conflicts of interest are dealt with under sections 40 and 41 of the Condo Act. Under these sections, a conflict of interest is when a director or officer's interest in a contract or transaction, whether direct or indirect, is material. So section 40 states that all board members have an ongoing duty to disclose any material conflict of interest in a contract or transaction to which the condo is a party or will be a party. The disclosure must describe the nature and extent of the interest and must be entered into the minutes of the meeting at which it is made. The director is then not allowed to be present during meetings or votes regarding the contract. What is material is fact specific and will depend on the circumstances, but generally refers to a personal or financial interest that could affect a reasonable person's judgment or influence their decision. Section 41 of the Act confirms those same disclosure requirements, but for officers. So a conflict doesn't automatically terminate a director or officer's ability to continue in their role or to transact business with the condo, but it does require that any conflict be made public and that they remove themselves from any decision-making process where a conflict exists, if that conflict is material. Under Section 37 of the Act, directors also have a duty to act honestly and in good faith and in the best interests of the condo and its owners. If a conflict is not disclosed where a director has the ability to gain a personal benefit and they're not removed from the decision-making process, this duty can't be fulfilled and they may be held liable for breach of their statutory duties under the Act. Any contract or transaction entered into under these circumstances is also at risk of being challenged and set aside, although there may be an ability to save the contract under Section 40, which would include a vote of the owners to confirm that contract or transaction. So there are two issues or failings that we see with sections 40 and 41. First, they only deal with contracts and transactions and don't provide any guidance for other conflicts that might arise, as John briefly mentioned earlier. As well, there's a requirement for current ongoing disclosure of conflicts, but there's no standard that confirms the disclosure must be accurate or true. Some potential conflicts could include a director who is also acting as the superintendent and performing maintenance work for the condo, directors who get elected to the board just so that they can be involved in service contracts and then get kickbacks. Kickbacks can be difficult to uncover, but some clues would be a director who strongly promotes one supplier or contractor over another, especially if there's no clear reason for doing so, or there's some other unusual circumstance, such as that individual recommending the supplier or contractor in the first place. This would also apply to property managers as well. Another conflict example could be a director who's complaining about noise issues in their unit and then decides to investigate themselves in their joint capacity as both an owner and a board member. So what do we do about this? How do we fill in those gaps that the Act doesn't cover? So the board should engage in a discussion and have it noted in the minutes about the duty to disclose what a conflict of interest is, which would include both actual and perceived conflicts, and that participating in discussions and decision-making where a director has a material conflict of interest is prohibited. The best way to confirm when a conflict arises, disclosure obligations, as well as consequences of a conflict or a failure to disclose, is by passing a bylaw, as well as creating a code of ethics and a code of conduct for directors and officers. So under subsection 56(1)(a) of the Act, the board can make bylaws governing the qualification, resignation, and removal of directors, which would include a requirement that directors execute and agree to abide by a code of ethics and code of conduct, and can be disqualified for failure to execute the code or due to a breach of any of the provisions of the code. So a code of ethics is a set of principles based on values and morals by which the condo makes decisions about what is right or wrong. So it governs decision making. For example, the duty to act honestly and in good faith. A code of conduct is a set of rules and regulations that explain appropriate behavior in specific situations. So it governs action. For example, this would include a confidentiality provision whereby any information obtained in the individual's capacity as a board member at a board meeting is to be kept confidential and is not to be disclosed. So the bylaw would make reference to the code and confirm the obligation of directors and officers to execute and abide by it. Without that bylaw, there's actually no way to enforce compliance with the code and any other requirements regarding conflicts and disclosure that the condo decides to implement. So this is where you would define all circumstances of conflict and what the solution is, such as requiring a director to be recused from any meetings and voting. So in addition to the bylaw and the code, the board should also take reasonable steps to ensure that the obligations of each director are clear and to satisfy themselves that they have conducted necessary due diligence to confirm that there has not been or will not be any conflicts of interest. So this would include requesting disclosure of any conflict of interest from everyone present at the meeting. The minutes of a meeting where a contract or an issue is to be discussed or voted on, which may present a conflict, should note the requirement of a board member or property management to provide written disclosure of any conflicts of interest to the remaining members of the board, and that the same is an ongoing requirement. So again, all those present at the meeting should be asked to disclose any potential or actual conflict. As always, if there is any question as to whether a conflict of interest has arisen, you should speak with your legal counsel. Next slide, please. So next up, we're going to talk about property management. So under Section 52 of the Condominium Management Services Act, managers are required to disclose to their client any material interest that they have in a contract and obtain the written approval from their client before entering into that contract. The manager is not to be present for the board's discussion about the interest in the contract unless the board consents. So essentially, the conflict can be waived by the board. There's also a code of ethics contained within one of the regulations of the CMSA that managers are required to abide by, which includes, amongst other things, that they use their best efforts to prevent error, misrepresentation, fraud, or any unethical practice, that they not engage in disgraceful, dishonorable, or unprofessional behavior, and that they promote and protect the best interests of their clients. Any failure to comply with the code of ethics is to be dealt with by a discipline committee, which may include paying a penalty to the CMRAO if found in breach of the code. So an example of a manager's conflict of interest could be the management company also having a construction arm, or a manager having a material interest in a contract or transaction. A manager receiving kickbacks from a service contract is obviously a concern. So some signs to look for are if the manager is signing contracts without authority from the board, or if they're recommending or pushing for a certain contract with no real reason. While there is some comfort in the CMSA requiring disclosure of conflicts to the condo, the board should take further steps to reduce the possibility of conflicts and to confirm the corporation's procedure for when there is a conflict. So first, the board should look at the management agreement and make sure there's a provision in there about disclosure of conflicts, and that the board understands what that means for the condo. Conflict of interest should also be defined. The board should confirm if the management company has a policy regarding managing conflicts, and if so, this should be included either directly or by reference to the management agreement. The board should conduct due diligence on all contracts and transactions and any other issues that might present a conflict. Look for any conflicts, such as the manager's family member being the owner or being otherwise involved in the business of one of the proposed service providers. Also at board meetings, just as recommended for directors and officers, managers should be asked for a declaration of conflict. And if there is a conflict, the manager should not be included in any discussions or decisions regarding the contract or issue of which they're in conflict. So now I'm going to turn it over to Shannon to talk about conflicts of interest with respect to lawyers.
Perfect. Thanks, Julia. So another type of conflicts to consider are those involving legal counsel. So how does the Law Society of Ontario define conflicts of interest? So pursuant to Rule 1.11 of the Rules of Professional Conduct, the LSO defines a conflict of interest as the existence of a substantial risk that a lawyer's loyalty to or representation of a client would be materially or adversely affected by the lawyer's own interest or the lawyer's duties to another client, a former client, or a third person. The risk must be more than a mere possibility, and there must be a genuine, serious risk to the duty of loyalty or to client representation. So according to this definition, a conflict of interest arises when a lawyer's loyalty or representation is hindered by the conflicting interests between the client and themselves, other clients, former clients, and other parties. So this separates into four categories of conflict. The first being personal interest conflicts, second being current client conflicts, and third being former client conflicts, and finally conflicts arising from duties to third parties. So personal interest conflicts are when a lawyer's own interest is capable of harming client representation and loyalty. A conflict of interest may arise as a result of the lawyer's personal interest in the client affairs or in the matter in which the lawyer is asked to act for a client. A personal interest includes not only the lawyer's own personal interests, but can also include the interests of others connected to the lawyer, such as the law firm or the lawyer's partners and associates. For current client conflicts, it may seem obvious, but Rule 3.43 of the Rules of Professional Conduct stipulates that a lawyer shall not represent opposing parties in disputes. So a lawyer in this circumstance would find it impossible to act without breaching the rules. In addition to the rules of professional conduct, lawyers also have a fiduciary duty to act within the interests of their own clients. So pursuant to section 3.410 of the Rules of Professional Conduct, unless the former client consents, a lawyer shall not act against a former client in the same manner, any related matter, or any other matter if the lawyer has relevant confidential information arising from the representation of the former client that may prejudice the current client. Also, the duties owed to third parties can potentially impair client representation and loyalty, and lawyers should consider the correctness of wearing more than one hat at the same time. So to determine whether there is a conflict of interest that would prevent a lawyer from acting for a client, the lawyer must first determine if there is a conflict of interest, and second, if a conflict of interest is found, they must then determine whether they may act despite the conflict of interest. So first, when determining whether there is a conflict of interest, the lawyer must determine the following. So who is the client? What are the duties owed to the client arising from the retainer? Whether those duties owed to a client, current client, former client, or any third party may affect the duties owed to the client. Whether there are any personal interests that may affect the duties owed to the client, and whether there is any substantial risk that the duty of loyalty to the client would materially or adversely affect the lawyer's own interests or duties to another client. If after reviewing it has been established that there is a conflict of interest, the lawyer must assess whether they can continue to act on behalf of the client. The lawyer must reasonably believe that they are able to represent the client without having a material adverse effect on the duties owed to a client. And if this is the case, then they may act providing there is consent from all of the affected parties, and the consent must be fully informed and voluntary after disclosure. So the consequences of a conflict of interest situation can be severe and quite costly. Acting with a conflict may result in a disciplinary action by the LSO for breach of the professional conduct rules. And the standard of care imposed on lawyers in contract and tort is to act as a reasonably competent and diligent lawyer. And the fiduciary duty imposed includes the obligations to provide full disclosure, to act with an undivided loyalty and exclusivity, and to maintain the client's affairs in confidence. And a breach of this can give rise to an equitable remedy. The LSO's mandate is to regulate the lawyers of Ontario in the public interest. Lawyers must comply with the Law Society Act and all related legislation, including regulations, bylaws, and the rules of professional conduct. The LSO has a statutory jurisdiction to receive and address all complaints regarding lawyers, and they will determine the appropriate steps on a case-by-case basis. So thank you, and I will pass you over to Ashley, who will be discussing bid rigging. Thank you.
Hi, everyone. Good afternoon. I just wanted to touch base quickly. Julia mentioned instances where management execute contracts on behalf of condominium corporations. Generally speaking, management should not be doing so. A board resolution should be passed authorizing 2 named board members to enter into a specific contract on behalf of the corporation. And those 2 named board members should be the ones executing it. However, if, practically speaking, the corporation does need management to execute contracts on its behalf, the board should ensure that it passes a board resolution to that effect, and management should not be doing that in absence of a board resolution. Okay, now bid rigging. Why should you care about bid rigging? Well, bid rigging essentially distorts prices in the construction process. So whenever you have a construction project, you're hopefully asking for bids, you're going through a tender process. And bid rigging essentially, it can undermine the quality of the services or the work that you're provided with. And it also deprives the condo corps or any other type of customers of the benefits of a competitive market. So what is bid rigging? Bid rigging under the Competition Act is where agreements are made between competitors, essentially not to submit a bid, to withdraw a bid, or to tender something that has already been submitted, or to withdraw their bid. Sorry, that was a bit confusing. Sorry, I'm having some computer issues. My apologies. It can also be a criminal offense, bid rigging, as well. And it can be prosecuted under Section 45 of the Competition Act or Section 47 of the Competition Act. Section 45 pertains to conspiracy agreements, and then Section 47 pertains to bid rigging exclusively. So essentially, bid rigging is when 2 or more competitors agree to fix prices, allocate markets or divide markets, or to restrict the supply or output of a product or service. Now, John mentioned this earlier, as I believe Julia may have as well. Bid rigging, there are some exceptions. So if the bidders advise the corporation asking for bids in advance that they are working together, that's an exception. And there's also an explicit exception in the Competition Act for agreements between affiliates, which is essentially when an agreement or arrangement is entered into between affiliates, potentially a property management company and a related landscaping service provider. So if you look at your property management contracts, you likely will see a clause in there about affiliates and explicitly providing the corporation with notice. So if the corporation is notified of an affiliate relationship, then it doesn't constitute bid rigging. So there's 4 main types of bid rigging, which is cover bidding, when competitors agree upfront who's going to win. And then the losing bidders make their bids less attractive so that the winning competitor wins. The second is bid suppression, when a competitor agrees not to submit a bid at all. Bid rotation is when competitors take turns submitting bids. And market market division is when competitors agree to divide up a territorial region or potentially customers or products in order to make themselves more attractive and to reduce the amount of competition. Could you please go to the next slide? In March 2021, the Competition Bureau laid multiple charges against 4 companies and their owners in connection with an alleged conspiracy to commit fraud and rid bigs for condo refurbishment projects. The companies that were charged were Trican Contract Incorporated and their owner, JCO and Associates and their owner, LAR Condominium Refurbishment Specialists and their owner, and then also a 4th company was CPL Interiors, and CPL was charged with conspiracy in the alleged scheme. In January of this year, CPL actually pled guilty to participating in the criminal bid rigging scheme and admitted that between 2019 and 2014, the 4 parties divided and allocated customers and fixed bid prices for approximately 31 construction projects in the GTA. And collectively, all of these contracts were valued at more than 19 million. So essentially, the condos and the owners are the victims at the end of the day, because they are paying higher prices for goods and services that they could have likely obtained had it been a fair, competitive bid process. If you could please go to the next slide. Thank you. So what are some of the warning signs for bid rigging? Some of the warning signs are if your condominium corporation receives 2 or more bids. So when the tender, you ask for tenders, they're received. And if the bids are identical, like contain identical amounts or use same like terminology is rather similar. Also, if the winning bidder does not accept the contract, that is a bit odd. So that's something to keep an eye out for. And then if the winning bidder subcontracts a portion of the work out to one of the other companies that submitted a bid for the tender process. And I guess the most glaring one is if there's a significant difference in price between the quote unquote winning bid compared to the other bids submitted. Some other small things to look out for, if 2 or more proposals or bids have similar handwriting or typographical errors, if they have come from the same place, same email address, or if they're received at approximately the same time. And if they use the same sort of terminology when explaining any price increases, or they refer to industry related standards, terminology that is very specific to each individual tender. Could you please go to the next page, please? Thank you. Oh, the next slide, please. Thank you. Oh, sorry, my apologies. If you could go back. Oh, sorry. All right, this works. Thank you. Sorry, I'm having some technical issues. So bid rigging, how can it be prevented? Well, if your corporation is going to be undergoing any major construction projects, you should be retaining an engineer or an individual qualified and experienced in the field to act as a consultant for the project. And that engineer would prepare tender documents and clear guidelines with respect to the tender process, as well as the project specifications, well in advance of the various competitors being asked to submit bids. So in order to maximize the size of, in order to prevent bid rigging, and ensure that that the process is fair and that you're receiving competitive bids, it's a good idea to maximize the size of your bidding pool. So you can, make the bidding with the requirements more inclusive. You can get to know some competitors potentially out of your direct regional area that are servicing your area. It's also very important to keep the bids confidential that are received. They are not to be disclosed. No content of the bids are to be disclosed. And it's also important not to advise any of the bidders who's been invited to submit bids and why. As I mentioned, tender specifications. This would be drafted by the consultant, and they should be appropriate based upon the type of project that the bidders are being asked to submit bids for. And what I always recommend is that the bidders list in their submission who or what companies, if any, they would be subcontracting any portions of the work out to. Because if you see that they're referencing some of the other bidders, that's a red flag that this bid could be subject to bid rigging. And if the bids don't make sense, there's a question, ask questions. Generally, your consultant would go through the bids and prepare a summary and provide you, the corporation, with their recommendation. But if something doesn't make sense, ask questions and reach out into the potential bidder that the corporation is considering awarding the contract to ask any questions that you may have before officially awarding the contract. And that's the tips with respect to bid rigging. I'll pass it over to Patricia now, please. Thank you.
Great. Thanks, guys. That was really good. Covered a lot of ground. And, one of the things that we also, hear about just directly is stealing and coming back to other sort of more obvious types of frauds. One of the things, though, that I notice when, I'm listening to the various approaches here is that there is a way to proactively manage these kind of risks. And the first thing is to identify the risks in your systems, figure out where the risks lie, and what is your system of checks and balances. So I'm going to take you through how it could happen, has it happened, and how we can prevent it. So condominiums, from some of the cases we've just talked about, are ripe to be ripped off, especially a decade ago. If you think about the level of cash flow on a monthly basis generated by a condominium, it makes you ponder how to keep it safe. As well, there's enough corporate governance structure. As well, is there enough corporate governance structure in place to create a system of checks and balances so you can catch any issues or gaps? If your systems are weak, your condominium is vulnerable. Today's systems are more than just good bookkeeping, though. Now you must be considerate of internet fraud schemes and reflect on how easy it is to steal someone's identity and their money. The condominium industry in Ontario was hit hard in 2011. Some of you may remember Mansour Murshid Khan, the president of Channel Property Management, managed to steal and or defraud condominiums and lenders of approximately $20 million in 2011. In the end, the amount was more like $22 million, and the egregious acts range from siphoning off money from a condominium via construction fraud and to forging documents to effect a loan. And that was where the majority of the money was stolen from. Lenders were fooled and believed in the integrity of Channel Property Management's team in proceeding with the loan. But why did they? Insurance companies were on the hook, as we understand, for the millions of money, the amounts of money that were lost. But unit owners also and condos did suffer losses. Here in this image, you can see this is Mr. Khan, but you can also see where the money went. The money went offshore to build him a house, which is on the left side of the screen, I think, for you, and a temple in the city of Bangladesh, or in the country of Bangladesh. So the challenge is, once the money is gone, there is nothing we can do. John made a comment about, calling the police, and I think that's very important, knowing whether or not there is criminal activity here and how to actually create the framework to somehow get the money back. But sometimes police resources are thin, and their reach of the law is not far enough to go into jurisdictions where there are no reciprocal extradition laws. So here, Mr. Khan was never really brought to trial. There were no charges that were laid against him for which he stood accountable for. And, you know, the people on his team, some of which were family members, alleged that they knew nothing. So in terms of what are the practical badges of fraud, John and I are now going to take you through some of the badges of fraud, and then I'm going to take you through some of the practical things that we see and how we can actually avoid them. Next slide, please. So John, why don't you tell us a little bit about what this slide is about?
Thanks, Patricia. In terms of the phrase badges of fraud, the court sort of coined this phrase, especially when looking at the likes of a fraudulent conveyance, when there's somebody that's trying to defeat a judgment, husband gets sued, knows he's going to lose the house because the house has value. He transfers the property to his wife to try and hide the property from creditors. That's probably one of the more common types of fraud that the court would see. And over the years, this term badges of fraud has been coined. And when Patricia and I were looking at this, we looked at really what are the badges of fraud in terms of condominium corporations. The 6 or 7 factors that are generally looked at by the court aren't overly comparable to condominiums. So we've done our own. Firstly, when we're looking at fraud and in terms of bringing a matter before a court or in litigation, the court has set a test for civil fraud. And the test is comprises of 5 elements. That there's a false representation of fact made by a defendant to the plaintiff, that the knowledge of the representation was false, there's absence of belief in its truth or recklessness as to its truth, an intention that the plaintiff acts in reliance on the representation, the plaintiff then acts on that representation, and the plaintiff suffers a loss in doing so. So when we look at that test, we look at the badges of fraud that the court has looked at, and then we try to come up with our own. We've put together these 6 here. 1, 2, 3, 4, 5. Yeah, we've got it right. 6, I can count. So we've got too good to be true. What does that mean? Well, if you're being offered a service, it really seems too good to be true. The price seems much lower, as Ashley had talked about, looking at the competitiveness of the bids. And when you look at something and see, yeah, that's much lower than everybody else. Well, let's go for it. It's the cheapest. It's the best. You know, not to say that is fraud in itself, it's not, but it's certainly one of the red flags that when we put together a full scenario, that's something that could definitely be looked at. Secret transactions is another one. Transactions that aren't papered well, that for some reason the service provider, contractor, whoever is not wanting to put in the bargain in writing. He doesn't want to have any paper trail, doesn't want to have any real documentation that could be tied back to him in any way. We've talked a lot about conflict of interest today already, and Ashley, Shannon talked about conflicts of interest in terms of lawyers. Julia talked about the conflict of interest in terms of property management, in terms of board members. A lot of potential for conflicts of interest. And there's always sort of an inherent bias when you're talking about a conflict of interest, that somebody wants something for maybe reasons that they shouldn't. Well, I want my brother-in-law to get this job, or I want my brother to get this job. Well, why? Outside of the relationship, is there anything else there? Is the property management pushing for a particular contractor for a particular reason? Have they been offered something if that contract is granted to the condominium corporation? Have board members been offered work in their units or improvements to their units for below market price? Things like that. In terms of our next one, unusual haste in decisions. If somebody's pushing for a decision to be made quickly, maybe a contractor doesn't want you to have time to price out the market, doesn't want you to have any time to negotiate, doesn't want you to have time to investigate the contract with legal counsel, doesn't want legal counsel to come back with, a whole slew of changes to the potential contract. Looking at the benefit retained by a director of property management ties in nicely with conflict of interest. It unfortunately happens. It's a problem within the industry, but it's something to look out for. And then the paperwork not being executed in person is something that we've seen, not commonly, but it's certainly raising its head a little more often. In that type of scenario, what we would find is a contract produced, contractor says, sure, let me take it away. I'll look at it at my head office or look at it with my boss. There's a contract that's signed, but it's not the contract that went out. Or maybe they type up word for word, except for a few material sentences. Maybe the price is more, maybe there is material changes in terms of when the money is paid, etc. Condo thinks that it's had its contract returned, that it was sent out, but it's not the same contract. And then when the amount is challenged, the contractor says, well, here's the contract. This is what you agreed to. This is what I signed. You gave it to me. Again, if somebody wants to take a contract away and say, I need to look at it with my boss, or I need to look at it with whoever, that's fine. That's not fraudulent in itself. But it certainly can be if the contract comes back and it's edited in such a way that it's very deceitful and not obvious that it's been edited. And unfortunately, that happens when we see it, we come back, changes come back to us as the changes aren't flagged, despite us saying, if you're going to make changes to this contract, please track changes. And then no changes are tracked. And we have to start and go through top to bottom to make sure that changes haven't been made, because we've seen it happen in the past. But Patricia, you've got some other sort of real world examples that you've seen and come across recently in the industry that you can talk about.
Yeah, absolutely. Thanks, John. And John brings up a really good point about also protocols. You know, one of the protocols is when we're negotiating contracts, we use a system called blacklining, which is part of our software. And it's good that you set out a protocol about highlighting changes as people negotiate back and forth. So it'll be very clear to anybody that somebody was acting in bad faith if they made a change and didn't highlight it. So that is one of the advantages of blacklining, of negotiating in very clear back and forth kind of techniques and processes. So it's clear to everybody that everybody's trying to be transparent. So going back to some practical examples, I wanted to remind you that Section 115 of the Condominium Act also confirms that a person who receives money on behalf of or for the benefit of the corporation, including money received from owners as contributions to the common expenses, shall hold the money together with interest and proceeds in trust for the performance of the corporation of its duties and obligations. This is something that's a little nugget that's buried in the back of the act, but it really imposes a trust on all monies that come into the condominium corporation and imposes that trust on anybody who touches the money. So here are some common frauds or deceptions in condominiums. A manager has work done on her house by a contractor who also is doing work for a condominium that she works for, and she is getting a discount. So how do we resolve it? Ensure that the management agreement actually contracts for this type of fraudulent behavior, allows for termination, demands damages, and requires disclosure. Julia was very clear in her analysis of the CMSA that this is a requirement. But John also said that we should ask property managers for declarations of any conflicts. You know, you may feel as a board that's okay, but if you don't know, you're actually, you know, negotiating in an environment where information to you that may trigger your decisions differently is being kept from you. I also wanted to highlight fiduciary insurance. When somebody steals money from you that is in control of your bank accounts and control of your money, you should have insurance as part of your corporation's policy, but you have to pay for that coverage separately. You have to ask for it separately. So if anything you take away from this discussion is, do I have fiduciary insurance for my condo corp? That's an important question to ask your broker. Another example is a president has his or her suite improved while the contractor is doing other work in the building. The contractor charges the corporation instead of the president. This can be difficult to detect. So how do we resolve this issue? First of all, make it abundantly clear through the code of ethics that Julia was talking about and the code of conduct is that that's a no-no. That is not acceptable, and that if that ever occurs, there should be consequences. Your bylaws can go that distance of, first of all, terminating somebody as a director, but also making it clear that any costs that are incurred by the corporation could be sought back from the unit owner. It will become common expenses. You want to be able to ensure that you can encumber ultimately the title of a unit through a lien. That is our goal. And we've talked to you before about indemnification provisions in the declaration being robust. This is part of that robustness that really needs to be now looked at in terms of the context of our decks. We've talked about bylaws, but if you want a slam dunk clear indemnification obligation that covers this kind of risk, should be in the declaration. Another example are checks are forged by a board member or a manager for their own benefit. How to resolve this one? Well, those bylaws and policies have to be clear. Your operating bylaw tells you who can execute a document on behalf of the corporation. I think earlier on, Ashley talked about the no-no of just having management sign contracts. That's abundantly true. And, only in very rare circumstances should that be allowed, because the management company is going to take on risk that it probably shouldn't, and it may not even be valid if you don't have that resolution. General operating bylaws generally provide that two directors sign unless there's a resolution that counters that. And so if you don't have the resolution, the contract is arguably not binding. So you really have to do all the check, the cross your T's and dot your I's when you're doing corporate governance. Checks are paid to a fictitious company for services that have never been rendered. This I've seen a multitude of times. How is it resolved? First of all, the condo where I saw it didn't have a good auditor. You need an auditor that connects the dots for the unit owners. Auditors represent unit owners, not the board, not the corporation. And the auditors that are really good at their field of work look for contracts, they look for minutes, they look for evidence that the work has been done. And your reports as directors, when you receive them, should actually confirm that management has confirmed that the work has been done. In the channel property management fraud, these poor unit owners in some of these condos were assessed by the board for work to be done in leaky garages, never done. And who was checking? Where were the directors? Right? They were putting all their faith in management. And don't get me wrong, there are fabulous managers that have earned trust in the industry. But there was no basis for that with channel property management. Repairs to a condo are not carried out. The monies disappear from the books and go to the manager or board member. Again, how is this resolved? We have to have good corporate governance in place, and we have to have trustworthy parties. We also should engage professionals. Ashley said that before on the bid rigging example. An engineer is a third party that answers to a professional association and wants to continue practicing their profession. If they sell out a condo, they've shortened their profession, no doubt. Their insurance will respond, but at least you've taken precautions. A manager or treasurer volunteers to buy furniture for the lobby or the party room. While doing so, he buys items for himself or takes points on his credit card. Okay, that's maybe an invisible piece. Is it fraud? Maybe not. I don't think so. But at the same time, how do we resolve it? The board can resolve it by allowing the board member to benefit from the cash back or the points. Say, thanks very much for a service well done. Thanks for putting it on your card. We actually did that at my condo where I sit on the board, and that was totally fine. But it had to be transparent to the owners. Another example is invoices are padded and include services that have not been rendered. Well, how do you do that? Well, with evidence, and especially if you're going to say the work was not needed, you have to have evidence. You have to have proof. You have to have an independent standard of what was needed and what wasn't. We've seen this actually occurring in some companies that were doing inspections for HVAC units, finding miraculously that there was something wrong with the multitude of HVAC units, but not having the scientific reports to back up their claims for mold or for other things that were wrong. Ask for the reports from an independent third party, somebody who is scientifically or otherwise qualified to provide you with the support that you need to justify even the contract. One of the things that concerns me today are contractors who are responding to insurance losses that overbill or overscope the rectification work. My question here, especially because we're talking about affordability these days more and more, we know insurance has been a hard market and that the costs of insurance are going up, is how do you get comfort that the work is not overscoped and not being translated into bigger premiums for your condo? And I'm not sure the answer to that question, but it's something to think about. Board members pay themselves a salary, even though condo owners have not voted a bylaw that would allow such payments. And they even sign their own checks. Now, we've seen this. I wouldn't be making it up. How is it resolved? Well, first get on the board so you can stop this. Hire a lawyer and demand the money be paid back. Figure out if there's a way to lien the units of these individuals so that they can't sell it without satisfying the losses. This is just blatant stealing, and it's without a valid bylaw in place. What about if a property manager takes an envelope of cash to ensure that a supplier's proposal is tabled, and they push forward that supplier? Well, how is this resolved? This is a hard one, because how do you prove it? Unless you have really clear, solid evidence, you have a sting operation, you can only then really call the lawyer and deal with the CMRAO complaint. So to me, these are all things that we need to think about further. It is ripe. And fortunately, you have property management teams that are managing risk, identifying risk, having systems in place, working with boards. But you still need the corporate governance infrastructure. You need the policies to say, why is this check and balance in place? What is going to the auditor? How do we verify this? Why? Because at the end of the day, you want your condo not to be a victim of fraud. Who pays for the fraud? The unit owner. There's nobody else that's going to pay this cost. And it's a tragedy when it happens. So, think about what the risks are, identify them, make sure you have processes in place, and do your best to manage the risk. And one of the things to do as well, transfer the risk from the condo to a third-party service provider that has insurance. Don't bring it upon the condo to manage all the risk. So if that's management has insurance. Sorry to the managers that are listening, I apologize, but you're in the business of this. Condo boards are lay people and are representing unit owners. We need professionals, and property managers are that, as well as other certified professionals, engineers, lawyers. Make them bear the burden so that you've protected your condo. So we're at the end almost. I wanted to know if there are any questions, but as well, I'm going to ask our panel to leave you with a thought on what they think you can do to protect your condo. We'll start with, how about John? We'll start with you since you started us off.
I knew you were going to pick me, Patricia. Gives me the least time to think about this. Generally speaking, if there's something that's wrong, or that you think something's wrong, whether as a board member or director, is just to speak up. If you ask questions and you get what you believe are acceptable answers, well, you've asked a question and you got an answer. If you speak up and you get brushed off, well, that would be a red flag to me. You also have your rights under the Act as a unit owner to requisition meetings and to force a board to talk about certain things if you really believe there's an issue. And if you're still not getting answers, retain a lawyer to, this is not meant to be self-serving in any way, but retain a lawyer to ask them to write to the condominium corporation and to ask them to produce documents, records, things like that. You've also got the records request that you can take to the CAT if you're not getting documents that you need. So there are a number of avenues open to try and explore things. But generally speaking, if you feel something is wrong, speak up and try and get to the bottom of it. I'm not going to talk anymore because I want Julia to have also little time to prepare for her answer. I'm going to ask her to turn over to answer next.
Great, thanks, John. I'm going to tie mine back into my topic, conflict of interest. I think it's important for boards and property management companies just to think about the different scenarios where a conflict could arise and develop a process to manage those conflicts. And don't forget about having the ability to enforce those standards or the process that you create. So again, putting that bylaw in place so that you can enforce the code of ethics and the code of standards, or the code of conduct. Code of standards. Yeah, that's it for me.
Julia. Ashley, I know you're having computer problems. Do you want to say a few words
Yep.
before you have to go?
Yes. I kind of want to mirror what John had mentioned. If something seems to be good to be true, ask questions. If you have any questions on any bid submitted, ask them. Before you award the contract is the time to do so. And it's also important, as John mentioned as well, that condominiums retain professionals like engineers to prepare the tender specifications and to help manage the tender process.
Thank you, Ash. Shannon, the youngest, but not the least important. So what do you think, Shannon, from your contributions?
Yeah, I would agree with what John, Julia, and Ashley have said. I think being mindful and having your eyes open, asking the appropriate questions, and having an understanding of, especially if you're a board member, having an understanding of your corporation and the property managers and contractors that are coming to the corporation. And like John said, asking the appropriate questions. I think that's the way forward to deal with this.
Great. Thank you. We have a question about bidding, the bidding process. Is there do we have a process that the board needs to follow as per the Act? No, we don't yet. We've actually recommended this, but one of the challenges in developing a process in a market that varies depending on location throughout the province is that there are not always suppliers that are available to do the bidding. So generally, a third-party engineer, and I always come back to engineers because they spec it, is depending on the size of the project, you get somebody who is qualified to look at a spec or design a spec and then have them put it out into the industry for bids, right? And one of the challenges there, of course, is that you're relying on the engineer to know people in the industry. And maybe, if you go with a reputable firm, they do know people in the industry and can give you a breadth of service providers. But then it's also the confidentiality that there is no sharing of any of the bid information. If you look at just case law on procurement, people where they find out about the breaches, the people who have made the bids could actually have a right to sue the corporation for breach of the rules of the bid, because the bid rules are there. And they will say often that there is confidentiality. So we could also inadvertently, through our failure to have a defined, clear, well-orchestrated process, be subjecting ourselves to lawsuits depending on the size of the project. And some of the projects these days are not small. I have one client that's doing windows for $17 million over 3 years. Those are not small contracts. And they did a fabulous job of tendering, by the way, using an engineer. So, but you have to put your mind to it. And I think there are good models out there. So in concluding, thank you for being with us. We hope you will join us for the next one, which is actually a very important topic wasn't even aware of human trafficking coming through condos. And we have Sandy Bibak, who is going to be speaking with us. She's from an organization that is taken this on as a cause. It's people who professionals that organize meetings, but she has a real passion about this topic. And she has been speaking to numerous people in the hotel industry. She's a veteran of that industry for over 30 years, booking conferences and planning events. And this issue came to light. So she's going to provide us with some insight. And then we're going to talk through what the impacts are on condominiums, what our risks are as well. So thank you again. Thank you for being here. Stay well, stay safe, and we'll see you again. Take care.